Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Before we get to our case today, real quick, next Thursday, November 12th at 9 p.m. Eastern Time, we'll be having our live Q&A discussion on naturalization. So make sure to like us and follow us on Facebook and Instagram and Twitter and whatnot so you don't miss it. Today we have a very interesting case, not something we see too often. Our client is a naturalized U.S. citizen. He filed an I-130 marriage petition for his wife, who is a native and citizen of Togo, back in 2012. It got approved 4 years later. We were not his attorney yet. I'm not sure why it took 4 years. That is a little long, but that's irrelevant to what happened here. So it finally got approved in April of 2016. In November of 2016, she went to an interview at the embassy in Lome, Togo. And at the embassy, when they were doing the interview, whether you immigrate with your visa and you come in as a permanent resident, or you adjust your status in the U.S. as a permanent resident, you need to get a medical examination. Anyone who's gone through this process knows that. So part of the interview, they look at the medical examination and make sure you don't have any diseases or conditions that would render you inadmissible under public health grounds. It turned out that his wife had a Class B condition. And a Class B condition is defined as something that is a physical or mental health condition, disease, or disability that results in serious or disability that's serious in degree or permanent in nature. It alone may not render the person inadmissible, but if there's a departure from normal health or well-being, it can be significant enough to interfere with the person's ability to care for himself or herself and require, this is the part they care about the most, require extensive medical treatment or institutionalization in the future. And what can end up, instead of getting it becoming inadmissible based on a public health ground, you end up becoming inadmissible based on a public charge ground. So the client goes to the interview abroad. They see that she has a Class B condition and says to the husband, you need to prove that you're gonna be able to pay for her medical expenses. We still weren't the attorneys at this point. I'm not sure if he gave them the documents or not. I believe he gave them what he thought would satisfy the requirement. But in June of 2017, NVC, or the National Visa Center, sends the I-130 approval back to USCIS. So for those of you who are unaware, when you file an I-130, that's the petition for an alien relative. We sometimes call it a marriage petition. When you file that, you file it no matter where your spouse is or relative that you're filing for in the US with USCIS. Once it gets approved, if the person is abroad, who's the beneficiary, they then transfer it to the National Visa Center. You do some steps there, and then once the National Visa Center you complete all the steps and pay your fees, they then send it to the embassy where you're going to have your visa interview. So you never want to go backwards in that process. It takes long enough to go forward in that process. When it goes backwards, there's an issue. So in this case, they sent it back to USCIS. The client then came to us, and this was in May of 2018. He hired us to help him prove to the embassy that, look, I'm going to be able to pay for my wife's medical care. He's a New York City corrections officer. He has a great health plan. That wasn't an issue. So we contacted USCIS in May of 2018. In October of 2018, we got a reaffirmation notice from USCIS, which meant that they accepted our proof that our client was going to be able to pay for his wife's medical expenses in the future. And then a month later, they then notified us they were transferring it back to the NVC, who then sent it back to the embassy for her second interview. And since that time, she has entered and has received her green card. So it's very important to understand the difference between what type of public health ground can make you inadmissible, not just on a public health ground, not what kind of disease or condition can make you inadmissible, not just on a public health ground, but also on a public charge ground. And if you've seen the back and forth at all lately with the courts with this new public charge rule, one of the things that they ask for now is proof of health insurance for everybody. But especially if you have any type of disease or condition like that, then you're going to have a problem if your spouse can or relative who applied for you isn't going to be able to show that you can support yourselves. That is all today for notable approvals. Don't forget that next Thursday, November 12th, 9 p.m., Attorney Aaron Shapiro and I will be doing our live Q&A on naturalization. Send us your questions. I think by tomorrow I will have some more information and an event page up. So make sure you like us and follow us so you don't miss that as well. Thank you for watching and have a great day.